Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgments pronounced now in the area of consumer law, criminal procedure and negotiable instruments. To know more about them, please watch the video fully. In the important judgment titled Hyundai Motor India Limited versus Shailendra Bhatnagar pronounced on 20th April 2022, the Supreme Court has held that the failure to provide an airbag system which would meet the safety standards as perceived by a car buyer of reasonable prudence should be subject to punitive damages which can have a deterrent effect. The facts of the case would be that a complaint made by the respondent concerning defect in a vehicle, particularly in relation to its safety features. The Delhi State Consumer Redressal Commission upheld his claim. The appellant preferred appeal before the National Consumer Dispute Redressal Commission. The National Commission dismissed the appeal, sustaining the compensation awarded by the State Commission. The order of the National Commission is under appeal before the Supreme Court. The Supreme Court has held that ordinarily a consumer, while purchasing a vehicle with airbags, would assume that the same would be deployed whenever there is a collision from the front portion of the vehicle. Both the commissions highlighted the fact that there was significant damage to the front portion of the vehicle. Deployment of the airbags ought to have prevented injuries being caused to those traveling in the vehicle, particularly in the front seat. A consumer is not meant to be an expert in physics calculating the impact of a collision on the theories based on velocity and force. In such circumstances, this court does not find there is any error in the findings of the two commissions as regards there being defect in the vehicle. This is a case where the Consumer Protection Act 1986 was applicable and Section 14 lays down the reliefs which may be granted. The directions as per the statute could be for replacement of defective goods as also punitive damages. Considering the fact that the dispute is pending for a reasonably long period of time, this court has applied its mind and its view is that a direction for replacement of the vehicle is justified in the facts of this case. The direction for replacement of the vehicle would not be treated as non-est having regard to State Commission's order. The fact that the consumer got the car repaired on insurance money would not impact the quantum of damages, which is partly punitive in nature in this case. If the reliefs granted in a consumer complaint fits any of the statutory provision contained in subclass 1 of section 14, it would be well within the power and jurisdiction of the forum to pass directions irrespective of the fact as to whether specifically certain reliefs have been claimed or not, provided that facts make out foundations for granting such reliefs. In any event, it is within the jurisdiction of the said forum to mold the reliefs claimed to do effective justice, provided the relief comes within the stipulation of section 14(1). This court finds that the relief granted to the respondent comes within the statutory framework. This court accordingly does not want to interfere with the decision of the National Commission. This court does not find the reasoning of the Commission or the operative part of the order awarding damages to be perverse. This court is also of the view that the directions issued against the appellant by the State Commission and upheld by the National Commission cannot be said to have failed the test of proportionality. This court holds so as it finds the subject defect to be of such nature that the provisions relating to punitive damages ought to be attracted against the appellant. Coming to the next important judgment titled Ramveer Upadhyay and another versus State of UP and another, pronounced on 20th April 2022. In this judgment, the Supreme Court has held that criminal proceedings cannot be quashed under Section 482 of the CRPC only because the complaint was lodged by a political rival. The facts of the case would be that the complaint filed by the respondent number 2 under Section 365 read with Section 511 of Indian Penal Code 1860 and Section 3(1) DHA of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. After a very long legal hustle, the session judge took cognizance of the charges and issued summons to petitioners. The petitioners filed application under section 482 of the CRPC, praying that entire proceedings as well as cognizance order be quashed, but the same was dismissed. Being agreed, present special leave petition has been filed. The Supreme Court has held that the allegations in the complaint case make out an offence under Section 3 of the Atrocities Act. It would not be proper to nip the complaint in the bud, more so when there are statements recorded in court under Section 200 of the CRPC. The possibility of the retaliation on the part of the petitioners by the acts alleged in the complaint after closure of the earlier complaint cannot be ruled out. Quashing the criminal proceedings at the very inception might result in injustice. Even though the inherent power of the High Court under Section 482 of the CRPC to interfere with criminal proceedings is wide, such power has to be exercised with circumspection in exceptional cases. Jurisdiction under Section 482 of the CRPC is not to be exercised for the asking. Therefore, the criminal proceedings cannot be nipped in the bud by exercise of jurisdiction under Section 482 of the CRPC only because the complaint has been lodged by a political rival. It is possible that a false complaint may have been lodged at the behest of a political opponent. However, such possibility would not justify interference under Section 482 of the CRPC to quash the criminal proceedings. The possibility of the retaliation on the part of the petitioners by the acts alleged after closure of the earlier criminal case cannot be ruled out. The allegations in the complaint constitute offence under the Atrocities Act. Whether the allegations are true or untrue would have to be decided in the trial. In exercise of power under Section 482 of the CRPC, the court does not examine the correctness of the allegations in a complaint except in exceptionally rare cases where it is patently clear that the allegations are frivolous or do not disclose any offence. The complaint case is not such a case which should be quashed at the inception itself without further trial. The High Court rightly dismissed the application under Section 482 of the CRPC. Now we are going to deal with the important judgment titled Ratish Babu Unnikrishnan versus the State Government of NCT of Delhi and another, pronounced on 26th April 2022. In this judgment, the Supreme Court has held that high courts should be slow to grant the reliefs of quashing a complaint under Section 138 of Negotiable Instruments Act at a pre-trial stage. The facts of the case would be that on a criminal complaint instituted by respondent number 2, the order under section 251 of the CRPC was issued against the appellant and the same was challenged. Delhi High Court dismissed the application under section 482 of the CRPC for quashing of the summoning order and the order framing notice issued against the appellant under section 138 of the Negotiable Instruments Act 1881. Being agreed, present appeals have been filed with the issues posed for consideration, and they are whether summons and trial notice should have been quashed on the basis of factual differences, what should be the responsibility of the quashing court, and whether it must weigh the evidence presented by the parties at a pre-trial stage. The Supreme Court has held that the burden of proving that there is no existing debt or liability is to be discharged in the trial. The legal presumption of the check having been issued in the discharge of the liability must also receive due weightage. In a situation where the accused moves court for quashing even before trial has commenced, the court's approach should be careful enough not to prematurely extinguish the case by disregarding the legal presumption which supports the complaint. Whenever facts are disputed, the truth should be allowed to emerge by weighing the evidence. Further, the quashing proceedings must not become an expedition into the merits of the factual dispute so as to conclusively vindicate either the complainant or the defense. The court should be slow to grant relief of quashing a complaint at a pre-trial stage when the factual controversy is in the realm of the possibility, particularly because of the legal presumption as in this matter. What is also of note is that the factual defense, without having to adduce any evidence, need to be of any impeachable quality so as to altogether disprove the allegations made in the complaint. Thus, the impugned judgment is rendered by applying the correct legal principles, and the High Court rightly declined relief to the accused in the quashing proceeding. Having said this, to rebut the legal presumption against him, the appellant must also get a fair opportunity to adduce his evidence in an open trial by an impartial judge who can dispassionately weigh the material to reach the truth of the matter.